Hello and welcome to the Legal Edition. I'm your host, attorney Mary Kay Elloian. Our show topic today is Going Dark or Getting Personal, the battle between data, privacy, and intrusion. Our guests are Bruce Schneier. He is an internationally renowned security expert. He is also a fellow at the Berkman Center for Internet and Society at Harvard University and a board member of the Electronic Frontier Foundation. He is the author of 12 books, including the New York Times bestseller, Data and Goliath, The Hidden Battle to Collect Your Data and Control Your World. We also have with us attorney David O'Brien. He is a senior researcher at Harvard University's Berkman Center for Internet and Society. He has authored numerous white papers and reports on cybersecurity and privacy for the Berkman Center and serves on the advisory board for Harvard's Open Data Assistance Program. Let's welcome Bruce Schneier and attorney David O'Brien. Welcome, gentlemen.
Hello.
Hi.
Great to have you with us.
It's great to be here. Thanks.
Thank you. Now, you've authored a report entitled Don't Panic, Making Progress on the Going Dark Debate. And that just came out in February of 2016. What does this report, what does this mean for the average American with a cell phone as well as law enforcement?
I can start. What we really want to write about is putting in context the state of surveillance. We're in the middle of a deep political battle over what the FBI is calling the going dark problem, that their fear is they're unable to conduct surveillance because so many modern devices are encrypted. What we're saying in our report is that surveillance is really much broader than that there are so many opportunities for surveillance. So for the average American, he or she is carrying a cell phone, which is fundamentally a surveillance device. It tracks your location at all times. It tracks who you talk to, when you talk to them, the messages, the things you search for on your browser, that all of these intimate aspects of surveillance are being collected. And it's not just your cell phone. It's every time you use an ATM machine or a car or walk by a security camera. That modern society affords so much surveillance that this notion that we just look at the very narrow slice of an occasional encrypted phone call or message really misses the whole point.
So what you're saying is there's more to it than the average person, it meets the eye. There is a much more, it's a deeper context of information that can be monitored. It's just not as simplistic as people think it is. Can you describe a little bit, I guess I'm a little confused as to what is it that the iPhone, the Apple case is all about?
So this is one particular case, and this is a hard case because the case is very specific, but the issues are more general, and the case doesn't map to the issues right. So I'd rather speak a little more generally. The notion is that during the investigation of crimes, the police regularly find phones, computers, electronic devices.
Right.
And on those devices might be information that could be evidence. And depending on the devices, depending on the information, the police have a greater or less capability to get at that data. So for the majority of the devices, there's no problem. If you have an iPhone, you probably use iCloud. You probably back up all your data. Data exists on the server. If you have an Android phone, it's probably all exists on Google servers. And it's easy for a government to get at that data. For some devices, depending on the type of device, the type of data, it exists on the device, and it can't be gotten. So what this case is about are the FBI's ability to affect the levels of security on the device such that they can get at the data if they want to, or conversely, such that you, me, an FBI agent, a congressman, anybody can protect their data from intrusion.
Now, but now this went before the judge. There was a warrant for that phone. It was used in the San Bernardino massacre, and they can't get in that phone. So what is being done at this point by the FBI and?
Sure, I'll talk a little bit about what's going on in the legal case.
Sure.
And of course, it falls against this backdrop that Bruce, I think, just painted very well, where for the last 2 years, the FBI has been raising alarms that encryption is more prevalent, it's becoming more difficult to gain access to certain types of communication during the course of surveillance. And so enters this case. And the attacks happen in early December. And as you mentioned, there's a phone at issue at the center of this case right now. It's an iPhone. It actually happens to be owned by the city of San Bernardino, not actually by the perpetrator who's deceased, too.
Yes.
There were other phones that the perpetrators were using in the case, but those were destroyed. All that's remained is this singular iPhone. It's an older version of the phone. It has a slightly older version of the software on it. And the FBI has been unable to access that particular phone. And so enters this case, right? So the FBI files an application under the All Writs Act, which is this gap-filling statute that dates back to the late 1700s. And it requests that the court order for Apple to assist them in opening the device. But what they didn't ask for was for Apple to decrypt the device. And that part right there is really critical because it's been part of the debate that's been going on for about the last 2 years and even a little bit longer if you go back. And instead, what they asked for is for Apple to remove some of the security features on the phone. And this would enable them to try as many passwords as possible until they could get into the phone, essentially.
And that's been a problem for law enforcement because, from what I understand, they only get 10 tries at this, and after 10 tries, that can be...
So it depends. There's an optional feature on the phone that you can choose to enable where the phone would erase all of its data after 10 failed attempts. Now, if you have a person that routinely mistypes your password, you might not want to enable that feature. If you are someone who types your password in pretty frequently and pretty regularly, and you're worried that someone might try to what's known as brute force the password, you might enable this feature. In this case, we don't know if the feature is enabled. If I was a betting person, I would say that it isn't enabled. It's actually not that obvious to enable the feature. The person who had possession of the phone really wasn't that security savvy. But there's no way of knowing. I mean, until you try the 10th failed password, you don't know if the feature was enabled or not. And the FBI is saying that they are concerned about this. Certainly a legitimate concern. But this case, I mean, to me, this is very much about the general.
And how many possible passcode combinations are there? There's about 10,000, right?
Well, it depends. If they enable the longer passphrase, it's much greater. You have letters or numbers. Most of us just use that numeric keypad. Back then, it was just 4 digits, which is just 10,000. But if he enabled the alphanumeric, he has the option of using letters, and it could be arbitrary length. Again, we don't know what kind of security is on this phone. There's no way to test it without simply doing it.
And for the sake of simplicity, let's assume it's the 4-digit passcode. About how long would you estimate it would take to break into the phone without the auto erase feature enabled?
Well, don't know. There are several issues. There's this auto erase feature. There are also delays.
There's the delay, that's right.
Normally, if I'm doing a brute force attack, I'm going to take your data into my computer, and I'm going to try password at millions per second. And so many things are broken that way, which is one of the reasons we're trying to get rid of passwords in so many places. Here's a physical device where you either have to have a person or a machine type the passwords in. What the FBI wants, they want Apple to design software that will automatically try passwords. They want to eliminate this after 10 you're out feature and also eliminate the delay. Apple also put in a delay because if you imagine your kid trying your passwords, they'll try 10,000, right? They're bored. They have nothing better to do. But if you make them wait 5 minutes, I just made this up, after every dozen or so attempts, it gets much longer. So there are those sorts of features enabled on the phone.
But from what I understand, after reading some of the statutes that are in play here, 47 U.S.C. Section 102, under Section B3, it states that a telecommunications carrier shall not be responsible for decrypting or ensuring the government's ability to decrypt any communication encrypted by a subscriber or customer unless the encryption was provided by the carrier and the carrier possesses the information necessary to decrypt the communication. From my understanding, that is what Apple is hanging its hat on because they're saying that they are not in possession of a means at this point in time to decrypt that.
So that's CALIA.
Right.
And this was the law that came out of Congress during the first crypto wars, which is the 90s. This is actually a debate we've been having for decades. And back then, the FBI was worried about encrypted phone calls. And AT&T was selling this encryption device that they wanted to backdoor. They were worried about telephony going over digital means. So they passed a law requiring phone companies to make their systems eavesdropping capable. But in there was that caveat, that the phone companies did not have to provide the assistance unless they're the ones who did the encryption. So if some third party did it, it wasn't their problem.
Right.
They were a common carrier. And what the Apple is saying is that the All Writs Act, which seems to be this catch-all of if Congress doesn't act, we can start demanding things.
Right.
Apple's saying, look, Congress did act. They
right.
passed that law, 1996. They deliberately excluded us. So how can you use this law to try to rope us in?
And I think that gives them the upper hand in that particular argument because Congress had spoken and they had exempted that particular issue specifically.
Well, maybe. Unfortunately, this is an area where there is not a lot of law. So normally in the course of cases, as you know well, we rely quite a bit on what courts have said in the past to determine what we should do in the future. And in this case, there certainly isn't a lot of law on point. But the controlling case at issue is a case called New York Telephone Company, which dates back to the 1970s. It was a Supreme Court case. And under it, the Supreme Court interpreted that there are some limits to the All Writs Act. It's not a completely gap filling. It doesn't fill every gap, in other words, in terms of its statutory authority. But you would have to determine whether the ask, essentially, is whether it's reasonable or not. And so whether what the government is asking Apple to do in this case, whether it would pass the reasonableness test.
And there was the case in New York that I think you're referring to was a drug case where the phone was encrypted and law enforcement can't get into that.
It's a very similar set of facts, slightly different set of hardware and software at issues. Of course, that just makes it all the more confusing. But we're seeing some of the same arguments presented in that case. And of course, we have an opinion from the magistrate judge, as we are in the San Bernardino case.
So the issue here, this is all capable of repetition. The same issue that is in the Apple iPhone case with regards to the terrorists in San Bernardino is applicable elsewhere, the same type of law enforcement issue of getting into these phones. But recently today, it actually was just yesterday, there was an interesting phenomenon that took place. The FBI and the Department of Justice backed down on a motion that they were pressuring to, I believe, get Apple to
That's right.
to
I'll
comply.
set the stage here. I mean, we were already in poise. This was like the nerd Super Bowl, really, because we were getting ready to watch the debate, which was supposed to happen actually this afternoon, and there was an 11th hour filing. The Department of Justice asked the court to vacate the hearing that was supposed to be today. And they did that because on Sunday, so just a couple days prior, they'd been approached by some unknown third party, they haven't disclosed whom it was, that had a method for getting into the phone. And they asked the court for some extra time to test out that method to see if it would work on the San Bernardino phone, and do so in a way where it wouldn't destroy the data on the phone.
Mm-hmm. So that's being suspended right now, that hearing?
That's right.
So for 2 weeks. And for me, this is kind of frustrating. I mean, I would like to see some clarity on this issue. It's not about this phone in this case. It's about the precedent.
Right.
And from the beginning, we knew that the FBI wanted the precedent. They chose a case that had very good press optics, that they could get broad public support. They really thought they had a win here. And the fact that there was such great public opinion against the FBI, I mean, for weakening security for all of us, I think surprised them. So we don't know anything about what the FBI is thinking. Why didn't they go ahead with the hearing? What is it about this access method? And just to put this in context, yesterday there was another flaw reported in the Apple iPhone. So a group of researchers from Johns Hopkins University last fall found a very serious vulnerability in iMessage that affects the security of those messages. They reported that vulnerability to Apple and have between last fall and now been working with Apple to fix the vulnerability. So on Monday, Apple released a new version of their operating system, version 9.3. You can download it. You should install it, which closes that vulnerability. So here's an example of a vulnerability discovered by researchers who tell Apple uses that knowledge to make all of our phones more secure. Now here's this other case where there's some unnamed third party, probably some cyber weapons arms manufacturer, who sells these vulnerabilities to countries, to governments, approaches the FBI, let's pretend it works, uses it to get into this phone. What happens now? That vulnerability exists. My phone, your phone, the phone of everybody in the world is vulnerable to this attack. Is the FBI going to say, hey, you need to tell Apple, you need to fix our security, or are they going to say, hey, neat, I got a way into iPhones, let's keep everybody insecure, I'm going to keep that in my pocket?
Yeah, this is a slippery slope. There's no question about what's going on.
It really
here.
illustrates well, I think, the cat and mouse game that is
Yes.
security
Yes.
in computers, because it's offense and defense, right? And when you're playing the game of security, as Apple is, right, they're playing defense, and there's an offense out there, and they're always a few steps ahead. It just depends on how quickly Apple can fill some of the holes that it finds.
Well, what was interesting when I read your report, one of the things that I noticed you say, we argue that communication in the future will neither be eclipsed into darkness nor illuminated without shadow. From what I understand, reading this, you're saying that the market forces and the commercial interests will make limits here of different encryption offerings. Can either one of you explain that?
So that's basically surveillance is the business model of the internet right now. And most of the services we use spy on us. Like Google, Facebook. And this narrow iPhone usage is an exception. And we, in general, use these services that just don't have encryption. Right? We have our data up on iCloud. We have our data in Google servers. And we do that because we get valuable services from those companies. Those systems are not encrypted because we want Google to be able to do work on our data. We want them to organize our email. So for most of us, for most data, there will be this unencrypted path because that's what the market is demanding. I mean, I as a privacy person, can want more privacy from these companies, but in the near term, I'm not going to get it. So this is a narrow exception, that in most cases, the FBI is not stymied. And there is so much more information being recorded now than there ever was, that the FBI to focus on this one narrow thing and say, we're going dark, is very myopic. Mm-hmm. And they're really missing all of this illumination from all of this data being collected about all of us as we go about our daily business. Mm-hmm.
Now that you've said that, let's talk a little bit about the Internet of Things, and in particular the OnStar. There's been cases with the OnStar system.
Well, with a competitor related to OnStar,
and that
but very much
well.
like that same system.
Same type of system, whether it's OnStar or not. It's a communications type of system in a vehicle. And from what I understand, there's been requests to use that system to eavesdrop on the persons in the vehicle.
And this is a case that's 13 years old, so the Internet of Things wasn't even a catchphrase yet, and now it is. But we can go back 13 years and we can see that there's some precedent for this. The story goes that at the time, the FBI was surveilling these two gentlemen who were thought to be part of organized crime. And they were having a very difficult time tapping into the conversations. And it's in part because these two people were instead always talking together when they were in a moving vehicle. And so the FBI had this idea, right? We'll tap into the OnStar-like system of the car. It has an onboard microphone. You can call into a concierge service. They could diagnose problems with the car and so on. It's integrated into the car systems. We could turn it on and we could listen to the conversation as it's happening in real time, all without placing a bug in the car. It was actually pretty brilliant back then. So they requested that the court allow this type of search to take place. And it was batted around a little bit between the district court and the appeals court. In the end, the Ninth Circuit did not allow it, but only on very narrow grounds. And the reason was because turning on the microphone would require turning off the safety systems in the car. And so they said, well, because you're turning off the safety systems, that makes us far less comfortable. They didn't say anything about the merits of the case and whether it would otherwise be allowed under the Constitution
I read that
or statutes.
I read that was a closed case, though. And it turned on very unique circumstances.
And it opens the door widely, I think, for the Internet of Things to be the next big surveillance vehicle.
Because generally, these things are going to collect data about us and our environment. And it might be something as benign as the temperature in our houses that the thermostats collect. Or it could be the voice right, for these microphones, and think of either OnStar or Siri on our phone, or that Amazon Echo, which you talk to and then you buy stuff. So the real general question is, who has the ability to turn on the collection, to collect the data? Who is allowed to know about it? Is, in general, someone allowed to turn on one of those collection devices in your home, in your vehicle, on your person, without your knowledge and consent? Right?
And it's
the government
not just our home, too, right? So, I mean, cities are going smart, right? Lights in cities now have microphones and cameras sometimes mounted onto them directly. Cities are pulling in data from all sorts of sources. There's a lot that's changing. It's really a tectonic shift that's going on under our feet. And we can't look at appliances the same as we used to and just think, well, that's just a washing machine. Well, it's a washing machine, but it's one that has a computer, and it also has microphones and cameras and all sorts of sensors.
And actually what it really is, it's a computer that cleans your clothes.
Yes.
I mean, right, your phone is a computer that makes calls. Your car is a 20 to 40 computer distributed system with 4 wheels and an engine. That these things are computers first and objects second. So really everything's being flipped on its head.
Right.
So these cases that are ostensibly about your computer or your phone are really about everything, because everything is now a computer.
Now, did a lot of these, I don't want to use the word paranoia, I don't want to use that word, but do you think a lot of the FBI's revelations and want to get into these phones and really being adamant about this, did Snowden have anything to do with any of some of this that's going on today? Edward Snowden?
So I think he did, because fundamentally this is about trust. You know, it's interesting. I just talked about this vulnerability in the iPhone, which Apple patched yesterday. And I told you to download the patch. You, everybody, will download it and install that patch without thinking twice. You won't analyze it. You won't look at what it does. You won't demand proof that it's not malicious. You will just download it. Why? Because you're trusting Apple. Right? A lot of us trust Apple that they are acting in our best interests. Why do we want to give the FBI that power? Because some of us don't trust the FBI. We don't trust that they are going to behave properly, that they're not going to twist the law, they're not going to use it to spy on ethnic minorities, that there's all of this secret law happening and we don't trust it. And some of that is because of Snowden. Some of that is because of overreach due to 9/11, but some of that is because of what Snowden showed us the NSA was doing, how the secret courts operate. This Apple case right now is happening in public. Usually these things happen under seal. Usually we wouldn't know about it. The fact that we know about it seems to have been an FBI PR move because they thought they had a really good press case. So I think a lack of trust undermines this a lot. If we trusted the FBI, if there was transparency, oversight, accountability, I think we would by and large say, yeah, it's okay for the FBI to put it up there on my phone because I know they're not going to abuse that privilege.
So basically, you think the American public would say, okay, I don't mind them listening in if they're going to catch the bad guys, if they're going to prevent terrorism, if they're going to prevent another San Bernardino, another Paris attack. You think that most people would be okay with that?
I do not. I think if the world were different, if there was this trust in the FBI, in the U.S. government, at a very high level, I think people would be more likely to say yes.
At a high level, but then...
I think fear also plays a big role here, right? Because it's hard to go a few weeks or a month or two without hearing about a terrorist plot or another terrorist attack. And this week, of course, we have more devastating news from abroad. And if you look at statistically, what is the impact on a population? There are plenty of other things that kill us on a day-to-day basis that aren't terrorists. But yet there's something about terrorism. I mean, this is why it's called terrorism, right? It inspires fear. And it's very good at that. And it's also good at getting people to think in this way that, well, we should never let this happen again. We should open up everything to the government and allow them to see whatever they want.
And to me, this would be a disaster for security purposes. I mean, a lot of my opposition to giving the FBI this capability is that it makes us all less secure. That any capability that allows the FBI to get into a device, others can use as well. And whether it's criminals or terrorists or other governments, that in this particular case, giving the FBI this tool to get into this Apple phone makes all of our phones more vulnerable to all of the threats. And as long as these cyber systems are being used by our government officials and critical infrastructure, by business, by all of us, that is simply too risky. And for security purposes, we want these phones to be as secure as possible, even though that means, in some cases, the FBI doesn't get data. That is a perfectly reasonable price to pay for the increased security we get by nobody being able to get that data.
But on the other hand, on the flip side of that, the terrorists know that, the drug cartels know that, and it's actually working for their benefit. So what would be the solution here?
Well, there's a limit to what we can do here in the United States. So if Congress wanted to, tomorrow it could pass a law that banned encryption. Can't put it into commercial products anymore, can't use it as a citizen. But that only is going to extend to the edge of the borders of the United States. It's not going to go any further. And there's a genie out of the bottle type of a problem here. So years ago, back in the 70s, when academics started publishing on encryption, people started creating products not that long after. And those products are now open source. They're freely available. They're everywhere. They're all around the world. We're never going to get those products back into the box now that they're out there. And that's what will happen is, to our detriment, we might, if this hypothetical law were to pass, right, we wouldn't be able to take advantage of the security that encryption can provide tomorrow. However, our adversaries will be able to use it freely abroad because it's still available over there. And there's just so much fragmentation in the ecosystem. This is a global marketplace. We can't just think of this as only being here in the United States anymore, that we're not going to be able to rope things in. And so for that reason, I mean, it might make sense to have a more pro-security stance, more defensively minded than offensively minded.
I did a study of foreign encryption products a couple of months ago, and I found over 500 that are freely available, some for actual free, some for pay, but all available to anybody who wants them, made by dozens of countries all over the world. And all would be available to anybody who wants to use it. So my fear is any vulnerability that we force into something on iPhone will affect all of us negatively, because we're just going to use the default. Any criminal terrorist that wants the security is going to download one of those tools, going to get the security. So we're not getting security against the people we want to eavesdrop on. We're making ourselves vulnerable to eavesdropping, and it's kind of a lose-lose.
Mm-hmm. And one of the things, too, a lot of the chips and a lot of these products are actually manufactured outside of the country, so you don't know what is being embedded in the Apple or whatever product it might be that you're purchasing, whether it's an Apple product or someone else's.
Rumor has it that even the president who has an iPad uses one that's been modified. The chips have been replaced with other chips that are thought to be more secure.
So
I know I can't get a specially modified iPad. I mean, but it's a question. Why can't the NSA do that for all of us? Right? The NSA can make the president's iPad more secure. Why is the NSA limiting it to the president's iPad? I mean, what about my iPad? What about your iPad? What about the iPad used by workers at nuclear power plants, at airports? Right. Why not the iPads of every member of Congress, every state government official?
Right.
I mean, these are all, in a sense, critical devices to our society, and any expertise they have, I'd like to see more broadly applied. I'd like to see them applied to the iPads that dissidents have in China. I think that'd be a good thing to do for the world.
Well, to wrap this up, though, your feeling is that we shouldn't panic. We're making progress on this, and that maybe this issue will come another day when the court will review that particular case with the FBI and the Farouk telephone and.
Well, let's not panic, right? So we're not going dark as the FBI would have it. However, we talked a lot about the Internet of Things and some of the privacy implications of that. There are some real challenges on the horizon that we're going to have to grapple with soon. And right now, we're not ready for that. Not legally and not as a society, not even technologically. I mean, those devices are so insecure. There are reports every day about bugs and vulnerabilities that are found in them. We need to figure out a way to grapple with those things as we move forward.
Mm-hmm. Any final closing remarks?
I guess I agree. I mean, this is something that's not going to go away. And this battle between security in general and the ability to eavesdrop is not going to disappear. the notion that we have to secure our infrastructure not just against privacy violations, but against increasingly cyber-physical systems, secure our cars, secure our homes, against actual physical damage and potential loss of life. That's going to make this a much more real debate.
And of course, securing our First Amendment, Fourth Amendment, and Fifth Amendment rights as well.
That's right.
Thank you, gentlemen, for being here. It's been an absolute pleasure.
Oh, our pleasure.
Thank you.
Thank you. I want to thank our guests, Bruce Schneier and David O'Brien, for sharing their insights and opinions on the issue of going dark and the boundaries between privacy rights and intrusion. I also want to thank you, our viewers, for tuning in. For more information on today's topic and our guests, please visit the Legal Edition online at thelegaledition.com. And as always, this is for general information purposes only. It is not to be relied or construed as legal, business, or security advice. And please consult a qualified practitioner as to your legal, business, or security needs. Thank you again for joining us, and we'll see you next time on The Legal Edition.